Congresswoman Jasmine Crockett sat at counsel's table. Her posture was poised yet resolute. She had prepared for days. She knew what was coming. Thomas spoke first, his voice low, controlled. "Congresswoman Crockett," he said, "do you really believe the integrity of the court is preserved by filing suit after suit, challenging every decision someone disagrees with?" A ripple ran through the courtroom. His tone was polite on the surface, but the implication was sharp, a rebuke masked as inquiry. Crockett nodded. She answered, calm, her words deliberate. "Justice Thomas, I believe the integrity of the court is preserved when the law is accessible, when rights are defended, not when dissent is dismissed." He narrowed his eyes. He leaned forward, finger tapping the bench. "So your position is dissent for dissent's sake? You would bring this court into perpetual contest." He spoke faster now, pressuring pace. "You have filed motions on redistricting, on voting rights claims, on standing challenges. At what point do you stop interrupting the work of this court with litigation?" Crockett's face remained controlled, but her mind raced. She had anticipated this line. "Justice Thomas, challenges arise because practices harm people. My job is not to avoid discomfort for institutions. It is to ensure protections for individuals. If the court fears contestation, it loses legitimacy." Thomas's lips curled slightly. He pressed further, voice sharp. "You speak of legitimacy, yet you persist in attacking decisions the court has made. Do you trust this institution at all?" The chamber was still. Spectators leaned forward. Crockett inhaled, then responded with composure. "I trust the institution to follow the law, but trust is not unconditional silence. Respect demands accountability from all sides." Thomas lifted a thick folder. He flipped pages in silence, like a judge in a drama. "You cite accountability, but I see obstruction. You delay remedies. You push for reinterpretations, all in hope that the court might bend to public pressure." He looked up sharply, eyes skimming Crockett. "If the law is clear, why press these claims? Why this persistence?" He expected a stumble, a hesitation, but Crockett, unmoved, delivered her next line quietly, and it landed like thunder. "Because our country is clear too, Justice Thomas, and it demands that law serve people, not power." Her words echoed. Thomas's expression flickered. Silence. He cleared his throat. The courtroom clerk broke in to read the next docket. Thomas nodded curtly. He rose. His robes whispered as he turned and left the bench. The gavel never fell. In that moment, browsing lawyers and spectators all exchanged looks. The courtroom had shifted. The clerk announced a brief recess. In those minutes, whispers traveled quickly. Court officers conferred. Spectators murmured about composure, courage, and whether what just happened would reach beyond these walls. While the court is paused, take this moment. If you believe the full truth matters, not just edited transcripts, like and share this account. Because when one voice stands firm before power, many others find strength. When the court reconvened, the tension was unmistakable. Every camera operator, every clerk, every intern could feel it. Something unspoken had happened before the break. Clarence Thomas re-entered slowly, his gaze steady, but his tone more measured than before. Jasmine Crockett, still seated at the same table, looked calm, unflinching, almost serene. Chief Justice Roberts cleared his throat and gestured for the session to resume. We will continue with arguments regarding federal oversight in state voting administration. But no one was listening to the technicalities. All eyes were fixed on those two figures, the oldest and one of the newest faces in American law. Thomas leaned toward his microphone. Congresswoman, he began, let's return to the constitutional point. You seem to believe Congress has unlimited power to intervene in state election procedures. That is not what the founders intended. Crockett lifted her binder, opening to a marked page. With respect, Justice Thomas, Article 1, Section 4 of the Constitution states that Congress may at any time make or alter regulations regarding federal elections. That's not unlimited power, it's delegated authority. And it exists because history showed what happens when states act without accountability. The crowd stirred. Reporters scribbled furiously. Thomas frowned slightly. "You're interpreting history selectively." "No, sir," she replied quietly. "I'm reading it completely. The 15th Amendment didn't just prohibit discrimination in voting. It gave Congress explicit power to enforce that ban. When enforcement lags, rights decay. That's not interpretation. That's record." The murmurs grew louder. Even Roberts glanced sideways. Thomas leaned back in his chair, the faintest sigh audible through the mic. "And yet, when this court rules, you return again with new filings. Is that respect or resistance?" "It's persistence," Crockett answered. "And persistence is what democracy demands when justice is uneven." There it was, that simple, sharp line. The kind that gets replayed across news networks for weeks. Thomas tried to pivot. "Congresswoman, you speak with conviction. But passion doesn't make precedent. Law requires restraint." Crockett closed her binder gently. "Restraint, yes. But not retreat. There's a difference, Justice. You taught an entire generation of lawyers that the Constitution means what it says. I'm just asking we remember all the parts of it, not only the ones that comfort power." That line drew audible gasps. One reporter's pen dropped to the floor. Thomas said nothing. For a long 10 seconds, he simply looked at her, the kind of stare that used to end arguments before they began. But this time, it didn't. The Chief Justice intervened softly. "Let's take a moment to allow the record to reflect the Congresswoman's statement." The clerk nodded, typing furiously. Outside, word had already started spreading. A young journalist from Reuters, sitting in the gallery, posted a message. "Historic moment in the court today. Jasmine Crockett just held her own under direct questioning from Justice Thomas, and maybe shifted the room." Within hours, clips from inside the chamber, recorded legally from public seats, flooded social media. Viewers replayed the moment again and again. Her tone, her control, his pause. CNN's evening panel called it the most striking exchange in recent judicial memory. Fox described it as a new generation refusing to bow. MSNBC ran a headline, "Congresswoman Crockett Schools Supreme Court on Constitutional Balance." And though the court never comments on active hearings, insiders later confirmed what many suspected. Thomas hadn't expected the Congresswoman to cite case law, historical precedent, and constitutional language with such precision. One clerk even told a reporter anonymously, "She walked in like she'd been arguing here for years." In the following week, Crockett's team released a statement. "Our appearance before the court was not to challenge authority, but to clarify it. The Constitution does not fear debate, only silence." That quote made front pages nationwide. Even in legal circles, professors at Yale and Georgetown discussed the exchange. They called it a defining generational moment in constitutional advocacy. But perhaps the most telling response came from a retired federal judge who wrote an op-ed in the Washington Post. For the first time in a long time, a young lawmaker spoke to the court not as a subordinate, but as an equal voice in a living democracy. And Clarence Thomas? He made no public comment. But a week later, at a judicial conference in Richmond, he was asked about the incident. He paused, smiled faintly, and said, "The Constitution was written for argument. Maybe that's what keeps it alive." That was all. But for those who had seen the hearing, it was enough. Because on that day in court, amid robes, marble, and history, a single voice reminded the country that even power must listen. And that silence sometimes is not weakness. It's recognition.